Now, there are alternatives to guardianship. Guardianship should not be the first thing you think of when it comes to, okay, how are we going to manage decision making for this individual? There are things called powers of attorney. Powers of attorney are helpful, but in Georgia they are not absolute. In order to do powers of attorney, however, you must be over the age of 18, because you have to have the ability to enter into a contract. You don't have that ability under the age of 18. So you have to be over the age of 18. You must have capacity. And this is one of the big gray areas. You have to understand what you're doing to enter into these agreements. It must be an independent choice. And this is kind of a gray area because who actually makes independent choices? We all are influenced by other people. Hopefully you'll be influenced by what I have to say today and be motivated to do something and take action. But the way I usually view independent choice is, are you able to resist the influence of others? If you're able to resist the influence of others, then chances are you're more likely making an independent choice versus if you always do whatever somebody tells you to do, or if mom and dad put it in front of the child and say sign here and they'll do it without even knowing what it is, then chances are they're not making an independent choice. I write it must be in writing. It doesn't have to be in writing, but it should be in writing. The only way you're going to be able to show to other people that you have power of attorney is by presenting a written document, and that's why it must be in writing. It may need to be notarized. Certain powers must be notarized. Most of the time, the types of powers we're talking about regarding your children don't need to be notarized because hopefully they don't own any real estate, they don't own any property of significant value. But if they do happen to own real estate, if they do happen to own significant property, then their powers of attorney may need to be notarized. The healthcare power, the advance directive for healthcare, does not need to be notarized. The legislature tried to make that document as user-friendly as possible, and therefore all it needs is 2 witnesses. And the 2 witnesses, the document even explains what the witnesses should be like. They shouldn't be related, they shouldn't be the ones who are being granted the powers, things like that.